Just a minute, I'm clearing the table. Good afternoon, Mr. Chaskalson. Good afternoon, Mr. Madlanga.
Afternoon, Chair.
Afternoon, Chair.
Mr. Madlanga is moving an application for witness G to testify in camera.
Thank you. Mr. Madlanga?
Thank you very much, Chair. Well, I think at the outset, I'd just like to perhaps inquire as to if the commissioners have read the papers, whether I should traverse any ground over the ground that has been covered in the papers themselves, or whether there's any specific questions over the papers that the commissioners would like to pose.
I think rather present the application the way you want to, and if we want to engage, you will do so. But do that, please do that on the understanding that we've read the papers, so it shouldn't be a regurgitation of the papers.
Thank you very much, Chair. So, yes, we filed an application for our client's testimony to be given partially in camera, so not completely in camera, because our understanding of in camera, in legal practice means when you're giving evidence completely off the record, so to speak. So our client is willing to assist the commission, but there are some sensitivities, as the commission may well know, that he runs some covert operations, and there is a very high-risk unit that he's running based in Gauteng. Naturally, these are some of the details that I wouldn't want to spell out and name publicly right now. So we're of the view that given that Rule 4 of the Commission's rules do make provision for an application of this nature, we believe that this is an opportunity for the Commission to show that it does take the safety of, witnesses, and I'm not suggesting that there was ever any narrative on our part that the Commission does not take the safety of witnesses seriously, but I think it's an opportunity to reaffirm that perception. And then what makes this particular application pertaining to our client unique is that because the witness deals with informers and the likes and operational contacts, their safety may be at risk as well. Should, for instance, somebody who has witnessed our client with a particular informer, there could be conclusions drawn correctly or incorrectly that the particular individuals that may have been seen with the witness were acting in a capacity of, being informers and the like. And what makes it even more riskier is that there's also the risk that individuals who are socially incidental to the witness could also be seen as informers. So that's basically our submission. So what we're asking for, in principle, is for the evidence to be given remotely. However, it can be broadcast and
Remotely and off camera.
Remotely and off camera, yes, that's correct, Chair. Remotely and off camera. And if it is possible, we'd also request for, if the technology, if the Commission is in possession of this technology, voice altering technology. Otherwise, what we could do, and I'm just brainstorming here, what we could do is that we could borrow the process that is employed when a translator is used in proceedings, where there's a little bit of a buffer between the person giving evidence and the evidence being received. So in other words, where the witness could give his testimony and then somebody else speaks into the mic, because there is a world where the witness has a unique voice. I'm not saying he does, but there is a world where he does. So I think in principle, those are our submissions. We know that it's a Friday, and we want to keep it short. Thank you, Chair.
I'm just trying to think if, you say, for example, if someone is seen talking to the witness, the suspicion may be that that person is an informer. I'm just thinking about the recognition of the voice in that sort of context.
The recognition of the voice is not necessarily.
That is witness G's voice.
Yes, the potential risk of the recognition of his voice does not necessarily pertain to the fears that were articulated regarding him having been seen with other witnesses. It exists alone, but, you know, and I would like the Commission to take judicial notice, if I may, of the era that we're living in, where people are just connecting dots everywhere. You know, on social media, you've got X, you know, and people are just connecting dots. So what we're trying to do is we're just trying to be as prudent as possible to conceal the identity of the witness.
There are many witnesses who have testified before us here, and I remember very few of their voices. So I'm just saying, you know, maybe it may be, but that's not my final view. But getting the voice, distortion, may be a tall order. That's just at this stage. It's a prima facie or prima facie, depending on whether you're a Latinist. That may be a tall order. I don't know.
Chair, that is completely understood. I do not want to, you know, belabor the point or hammer the point, and if it is unreasonable in the circumstances, then
I'm not going so far as to be that strong, at least not at this stage. You said those are all the submissions you wish to make. Yes, Mr. Shaskalsin.
Chair, I accept Mr. Matlala's proposition that the witness cannot be visually identified. If he is running agents and informants, his face can't be shown because that will endanger the people who speak to him. It's not clear to me. Well, we have investigated whether we have voice-altering technology, and we didn't come up with any satisfactory results there. It's not clear to me that he will be identifiable by voice. And so it seems to me that the request for off-screen testimony that will nonetheless be streamed, but not with any visuals, is one which we would support, but we wouldn't go beyond that. There is an issue that I would want to flag, though, which is that, and it's not raised by Mr. Matlala, it is that some of the questions that I may ask this witness may render him identifiable with reference to information that is publicly available. And those are not questions I can avoid asking because they will be directly relevant to the inquiries of the Commission. And I would, I'd like to just place that issue before the Commission now. My proposal is that I could structure my questioning such that any questioning that would expose the identity of the witness can be dealt with in one particular session, which might have to be entirely in camera. But if the Commission is inclined to make a ruling of that nature, then it should make it in the form of a rule nisi, because we've given an undertaking to the media that we won't ask for a fully in-camera testimony again without giving 72 hours notice to the media to object. The witness is not going to testify on our schedule for at least another 3 weeks, so the 72-hour problem doesn't arise in this case. But I do think that, I think it's incumbent on me to raise that now, because otherwise we will bang into it in the middle of the hearing, and suddenly we will face a potential problem where the mere posing of the question, never mind the answer to the question, might identify the witness.
What we propose is not to make an order now, especially seeing that there will be a rule nisi anyway. So we suggest that between the two of you, you should put together a draft for us, which will then be publicized, obviously not less than 72 hours. Yeah, we'll just leave it to you then to put together something. Once you've agreed, you'll then furnish it to us as soon as you are ready.
Thank you. We'll certainly do that as soon,
Yeah, I'm
as,
happy
soon
to
as
do that.
possible.
Happy.
Yes. So the order for today will just be a stand down until we've received the draft.
Thank you. Sorry
Thanks,
for not
Chair.
arranging that in advance.
No. I assume it couldn't be foreseen. We will adjourn and resume at 9:30 on Monday. Let's adjourn.